Hello, this is Legal Clinic LWA 298 and this lecture is about access to justice and vulnerable people. Meeting a client for the first time is always interesting. They're always hopeful that you're going to be able to help them, and I used to always be curious about what their problem was and about whether they even had a legal issue. I used to let them talk a lot, and then I'd start to think about what questions I was going to ask them. The most important thing when I first met them was to not assume anything, and I found that fairly easy to do. And it was easy to do because I was interested in who they were and what they were saying and the way that they were saying it. It also allowed me to work out whether or not English was their first language. It would also allow me to watch their demeanour and see how much, if any, stress they were under. Usually a person who comes to a lawyer is under a degree of stress, and whether that makes them vulnerable or not is another matter, but that's something for you to consider and think about. When you're interviewing a client, like I said, let them talk. However, there's a point where in order to find out what the legal issues are, you're going to have to ask them questions, and that's your duty as a lawyer to do that. Make sure your questions are short. Try and be as open-minded as you possibly can to everything that they're saying. Try to make sure that you don't lead them with your questions, and even by the tone of your voice, try and make sure that you're as on their side as you can possibly be, so that they have confidence in you, and so that you can get the best story and the best evidence that you can, so that you can represent them well. Risk factors that indicate a person might be vulnerable in court or vulnerable and may need assistance are sometimes inherent in the nature of the crime itself, especially if they're a victim of domestic or racial, financial or sexual abuse, a victim of human trafficking, of a hate crime or discrimination or some other kind of exploitation. People for whom English is not their first language can have difficulties in giving evidence and also understanding what's required of them, even if they seem relatively fluent. People who are unable to read or write very well, sometimes they don't want to be particularly upfront about that, and it's something that you find out at a later stage, and something to look out for. People who have a mental or a learning disability, and all children, anyone who's under 18 is deemed vulnerable by the courts. People can feel anxious about giving evidence in court at the best of times. People can be fearful or intimidated if they have to face an accused in court, or even if they have to give evidence before a witness, and they think that they may have to suffer they may well suffer some sort of retribution because of the things that they're going to say in the witness box. This may cause them to withhold evidence. Also, people who suffer from an intellectual disability or who have some other kind of special needs may be intimidated by the process, and they're going to need special assistance in order to get their evidence out. Because equal access to justice in our system is the gold standard, then people who are deemed vulnerable by the courts can receive additional assistance both before they go to court and while they're in court. So if you believe that your client may be a vulnerable witness, then you can apply on their behalf, or they can apply for assistance as a vulnerable witness. And each state and territory has their witness assistance service scheme, and that's often run under the auspices of the Department of Public Prosecutions. It certainly is in the Northern Territory, and the link to the scheme is at the bottom of this slide. When your client is in court, or when the vulnerable witness rather is in court, the kind of special treatment that they could receive or are entitled to is that they may be able to have a support person in the witness box. There may be a screen or a partition so that the witness can't see the accused. The court may be closed to the public. You would probably be aware of that as soon as you walk into the magistrate's court. There are often courts that are closed courts. The witness might be able to give evidence over a closed circuit television, which means that they don't even have to be in the same place as the accused. Sometimes witnesses are also intimidated by other witnesses or other people that are somehow connected with the case. And if they're intimidated like that, then sometimes they won't give all of the evidence that they could possibly give. And there's an interesting podcast called Last Seen in Katoomba where just this was possibly the case in a coronial inquest. And I've got the link there for you, and you might want to have a look at it, or listen to it rather. I think it comes in 4 or 5 parts, but the really relevant sections, I've given you the time markers for them down there. Luke is a pseudonym for a very aggressive and intimidating witness. Heidi Wales was the witness that was potentially intimidated, and Phil Strickland was the counsel for the prosecution, or for the Crown rather. It was a coronial inquest. And he also explains the nature of a coronial inquest and the position that that an inquest can put witnesses in. So anyway, have a listen. As I said before, children are by their nature considered to be vulnerable as far as courts are concerned. Building trust and rapport is important with all clients, but building trust and rapport with children requires a particular skill set, and the rest of this lecture will be about the kinds of questions that children find difficult to deal with, and it also looks at ways that you can build a rapport with children. Some of these questioning techniques can also be useful in general as well, but more particularly they're directed at children whose attention spans will wander in a way that an adult's attention span doesn't, who have a different sort of an interest in the issue that they're seeing you about than an adult would. All right, there are questions that are problematic, especially with regard to children, arguably problematic in any interview situation, but particularly in regard to children. If you ask a child a yes or no question, they're going to want to answer you yes or no. They're highly unlikely to tell you that they don't know. So if you ask a child, can you tell me, do you know, was he or she doing at whatever, a certain place, they're going to want to work out whether you or not you want them to say yes or whether you want them to say no, so that they can concur with you. They're not likely to tell you that they don't know. The other form of question that isn't useful for children is the forced question. It's called a forced choice question. An example of a forced choice question is, were his shoes blue or green? Well, as it happens, his shoes were red. However, the child won't want to tell you that you're wrong, and a child again won't want to tell you that he didn't see the shoes. He doesn't know. The child will want to give you an answer and is likely to tell you that they were blue or that they were green. And of course, that if that has no basis in fact, then if that evidence is then presented in court, then it's likely to be quite easily discredited and disproved. Tag questions, I've spoken about these before. She wasn't there on Thursday evening, was she? And you've set up the entire situation for the child, and it may be a situation that doesn't even exist, but that's the next question, the presupposition question. The tag question also requires you to, as well as containing a supposition, it also requires a yes or a no answer. Child, as I've said before, is highly likely to say, I don't know. Presupposition questions. The classic one is, when did you stop beating your wife? Of course, you wouldn't ask a child that, but it presupposes that you are beating your wife, and children are very, very suggestible. So it's make sure that your questions are as open and as inquiring as you possibly can. All right, the structured interview approach assists you to do that, and we'll go through a few of the examples that Lyons gives us in the video that tell us how to approach children and ask them questions. So, what makes a forensic interview with a child different from any other question or answer situation the child will find themselves in? Children are in question answer situations all the time. They're in them at home, at school, and almost anywhere where there's an adult and a child. The thing is too that children think that adults know everything, so there's this huge power imbalance, and children rely on adults for the answers. So if you put a child in a situation where they're the ones giving the answers, that's an unusual situation. And in a forensic interview, the interviewer doesn't know the answers. That's why the interview is taking place. And there is a way to overcome the difficulty, and that is by giving really explicit interview instructions to the child, to tell the child that in this interview it is okay not to know the answer to a question. It's all right to tell the interviewer, the adult, that he's wrong. And I want to go through just 5 or 6 of those factors in a structured interview. And the structured interview that I'm looking at is one set up by Thomas D. Lyon, and the link at the bottom of this slide will give you a session with Thomas D. Lyon where he explains this structured interview technique in detail. The First instruction that we'll look at is the don't know instruction. It's an interesting one because children have been found to be more likely to answer yes or no to a question rather than say that they don't know, even when they don't know the answer. They'll still say yes or no, and this can be highly misleading if you're taking a statement or if you're cross-examining or a child, or if you're adducing evidence in chief. And the way that you would deliver the don't know instruction is this. Speaking to the child, if I ask you a question and you don't know the answer, then just say, I don't know. Now that won't be enough for a child. You'll have to give them an example. So you say to them, so if I ask you, what's my dog's name? What do you say? And the child will have to say, or think, or indicate to you in some way, often by the look on their face, that they don't know. And you say to them, yeah, that's okay. Good. That's because you don't know. You can't know. But what if I ask you, do you have a dog? The child obviously will be able to tell you, yes, they have a dog, or no, they don't have a dog. You can say, yeah, okay, because you do know that, because it's your dog. Let's look at the don't understand instruction. The don't understand instruction is an important one because research has shown that children under 5 usually don't understand what the word understand means. So if you ask a child, did you understand what I just said? They could say anything. And it wouldn't really mean much because they don't actually understand what that word understand is. So an approach in accordance with the structured interview approach would be to ask the child, if I ask you a question and you don't know what I mean or what I'm saying, you can say, I don't know what you mean. And then I'll ask it in a different way. And you have to give the example. So if I ask you, what is your gender? What do you say? And a child may say, I don't know what gender is. I don't know what you mean. And then you can answer and say, that's because gender's a hard word. So what about if I say, are you a boy or a girl? And then the child can say to you, oh, I'm a boy. And it will become apparent to them that a question can be asked and satisfied in more than one way. All right, next is the you're wrong instruction. The you're wrong instruction is one that can assist you to build rapport with a child because it's got the potential to flip the power imbalance that can exist between a child and an adult in a situation where the adult is seen as always right. It can also have fairly unexpected consequences for the child, which can make the child laugh. And it goes this way. The interviewer says, sometimes I make mistakes or I say the wrong thing. When I do, you can tell me that I'm wrong. The child will look at you and just go, what? I don't even know what you really mean there. And so you give the example. So if I say, you are 30 years old, what do you say? And the child might laugh, or the child might think that you're a bit crazy and say, I'm not. I'm not 30. And then you can ask, how old are you? and the child will tell you how old they are. And the child might have told you that already. My child might have said, "No, you're wrong, I'm not 30, I'm 8. All right, next instruction. Because children often think that adults already know the answer to the questions that they ask, because that's so often their experience at home or in school, it's necessary to give them an instruction that tells them that the person who's interviewing them in this forensic interview doesn't know the answer to the questions they're asking. They're genuine questions. So the ignorant interviewer instruction goes like this. The interviewer says, "I don't know what's happened to you, and I won't be able to tell you the answers to my questions. You're going to have to tell me the answers because only you know them. I don't." Asking children to promise to tell the truth can be problematic because often children don't know what a promise is. They don't know what obligation a promise imposes upon them. And so the structured interview approach requires that an interviewer says the following. "It's really important that you tell me the truth. Do you promise that you will tell me the truth?" Now, to distinguish between truth and something else, the interviewer then also asks, "Will you tell me any lies?" And for a fuller explanation of this, I encourage you to go and have a look at that video by Lyons. All right, the last element of the structured interview approach that we're going to look at is building a rapport and narrative practice. There are more instructions than this, and I encourage you to have a look at the materials on LearnLine, and also have a look at that Thomas Lyons video that I've referenced in the PowerPoint. All right, narrative practice is the art of story building, and that's what we do in statements, and that's what we do when we're adducing evidence in court. We're building up a story, and that story has a beginning, development, and an end. However, often when you're interviewing people, and not just children, but anyone, they're unlikely to begin their story at a beginning. They're likely to launch in the middle, and then they skip all over the place. Or they might begin at the beginning, and then they start skipping everywhere. And it's up to you to work out a logical sequence that will tell the story you want to tell in order to represent your client as best as possible. All right, the suggestions that Lyons makes are to ask the child what they like to do in the first instance. And the child might say, "Oh, I like to play basketball." So then confirm that they like to play basketball. "Oh, you like to play basketball? Tell me more about basketball." Which then invites them to elaborate on basketball. Another question that he suggests is, "What don't you like to do?" And the child has said, "Oh, I don't like reading." "Oh, you said that you don't like to read books." There's your confirmation. "And tell me more about reading books." So you're asking the child to elaborate. Once you've confirmed what they've said without judgment, then you ask them to elaborate on what they've said. And as soon as you bring a judgment into it, for example, if you're thinking, oh, you don't like reading books, you know, what kind of an idiot are you? You're going to shut the child down. And I think I said something regarding that earlier about interviewing any client. Try and keep your own judgments out of it. Another way of building a narrative is to ask a child about a recent event. A birthday party is the suggestion that Lyons gives us here. So tell me about your last birthday. Well, the child's unlikely to begin at the beginning. So in this example, this child has said they hit a piñata. That was the best thing about the birthday. Ah, confirm it. So you said you've hit a piñata, and then ask the child to elaborate. You know, what happened next, and start your sequence from there. You can build it forward, and then you can build it backward. And you would do that with any witness, really, or with any client. But with a child, it's a slightly different process, as you can see. All right, in conclusion, I just want to go over some of the behavioural characteristics that might alert you to vulnerability. If a person's difficult to understand and has no speech or limited speech and finds it difficult to communicate without assistance or interpretation, they may well qualify for assistance as a vulnerable witness. If they're having difficulty in understanding questions, if they respond inappropriately or inconsistently to questions, or focus on what might be deemed to be relevant small points rather than the important issues. Sometimes people who are under real emotional stress tend to do that. People who have really short attention spans, and people who can't read or write or struggle to read or write. If a person has difficulty telling the time, remembering their date of birth, their age, address, telephone number, difficulty knowing the day of the week, where they are and who they're talking to, may well be under a vulnerability and require assistance. People who are really eager to please and who repeat what you say to them after you've said it. That might be a sign. People who appear overexcited, or the complete opposite, who just appear unusually lethargic or uninterested. People who are confused by what is said or happening, are withdrawn or become violent and aggressive because they're confused. And people express strange ideas and don't understand common and everyday expressions. It may be some indication that there is a vulnerability there. All right, so how do vulnerable witnesses access assistance? There are witness assistance services in every state and territory in Australia. Our justice system requires it. It requires that everybody has access to justice. And if a person is suffering under a vulnerability, then they don't have the same access to justice as a person who isn't. And so it's to redress that imbalance. In the Northern Territory, the Department of Public Prosecutions offers the Witness Assistance Service, and I've just put the website down there, and you can have a look at all of the services that they offer. All right, well, thank you very much for listening, and I hope you enjoy the rest of your course in Legal Clinic.